Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. I wanted to make a video today talking about the difference between formal and informal probate. If you are about to enter a probate process, either because you are going to be the personal representative handling the estate's affairs, or you are the beneficiary of an estate that is about to go through a probate process, one of the earlier questions that needs to be made as that process is being set up is, are we going to do this formally or informally? And so a little history lesson might help first. There didn't used to be two different processes. There used to be one process, and that process kind of assumed that anybody going through the probate process needed a lot of court oversight because generally people could not be trusted to handle affairs correctly. And what that resulted in was a system that had a lot of court hearings, a lot of motion practice, a lot of lawyering basically, and it was very difficult to do the process without a lawyer. And in a lot of cases this was not necessary because the estate was generally, the beneficiaries got along, it was clear what needed to happen, there weren't really any complicated creditor claims, there weren't any assets that were very tricky, and yet everybody had to go through this process, right? Even people who generally had easy to handle probates. And so at some point along the way, the Colorado legislature determined that maybe there should be two different processes. One for cases like that generally people could get along and didn't need a ton of court oversight, but still needed some sort of process to make sure that things were done correctly and that disputes that did come up unexpectedly could be handled. And then a different process for situations where, okay, we definitely have something unusual going on here, or we do have a conflict, or we do need some sort of court oversight a little bit more proactively. And so what I've just described is the difference between the informal and the formal process. The informal process is the process that assumes good faith, assumes things are going well, assumes that everyone is kind of working in the best interest of everyone else. We don't have, we have a solvent estate, so we don't have creditor claims that are overwhelming the estate, and in general things are being done correctly. And so in that process, both processes generally, they're the same, right? I mean, the same steps have to be taken. There's still creditor notices, there's still applications, there's still notices that need to go to beneficiaries, and the administration has to follow the correct processes as far as who's getting what. If there's a will out there, the will instructions need to be adhered to. If there's not a will and we're going through the intestate process, those rules need to be followed. And so whether we're doing informal or formal, all of that applies. The difference is that in the informal process, there really aren't any hearings. The court's not proactively looking at things. When a personal representative applies to have an informal process opened, the court pretty much rubber stamps that document and doesn't do a lot of checking into whether the facts that were asserted in the application are true, as far as the little bit of verification, make sure that yes, we're talking about a person who passed away in this county, and that things appear to have been filled out correctly, but whether the errors have been listed correctly, whether we have the right address for the person, those kinds of things, the court kind of, again, they assume that the person applied is doing things right. And then as the process plays out and we do those creditor notifications and we notify the people who are involved and have an interest in this estate, as long as no beneficiaries or creditors are complaining, and as long as the personal representative seems to think they're doing fine, again, the court just assumes everything's going fine. The moment that someone does, who has an interest in the estate, does let the court know, like, hey, we got something going on here, then the court is there, they can have a hearing, but otherwise those are not being scheduled. In the formal process, it's the opposite. We do have a process where it's like, if you're going to apply to be a personal representative in a formal process, you actually do schedule a hearing. And there are a few points through the process where you do actually schedule, they're called non-appearance hearings, which is kind of an oxymoron, I guess. But what that basically means is it gives everybody involved proactive notice that if they are unhappy with the application that's been submitted, with the identity of the person who's asking to be named the personal representative, or whether there's other things about the estate that are expected to be potentially a problem. At that point, the date of that non-appearance hearing serves as the deadline by when they got to let the court know, like, hey, we really do want to come in for a hearing here. And so just a little bit more notification and, like I said, a little bit more proactivity is required by a personal representative doing a formal process. So that's the big difference. If you're trying to decide between informal or formal, I don't have any statistics on it, but my suspicion is that probably most states use the informal process, and it works just fine for them. If you are expecting there is a problematic family member out there, people are not agreeing, if there's going to be some sort of objection that you're anticipating to who the personal representative should be, if you think the estate might be insolvent, there's more creditor claims than there are assets, all of those things would be, okay, let's go ahead and do this as a formal process. And just to let you know, you actually can open one way and then close the other. And so, like, you could open an estate informally and then things come up and you realize, oh, this was contested in a way I had not expected, and so you close formally. So why would you want to do that, right? So closing an estate formally kind of starts a deadline running, and again, everybody who is involved in the estate has an interest. They get a notice saying, I am closing the estate, here's the date of the hearing, if you want to object to anything I've done, let the court know by this date and this time. And if they do not, if there is no hearing, then the court goes ahead and closes the estate, and everybody from that point on, the personal representative's liability ends 30 days after that, and because everybody had their chance already. They were already notified. In an informal probate process, that's not necessarily true, right? There was not necessarily any filing of the accountings or the inventory, and people were not notified necessarily that, or given a chance to object. And so the challenge with the informal probate process for the personal representative is that their liability continues for a year afterwards. Since the court was not really involved, we just want to give people a fair chance to make objections if they were not fairly notified or given a chance to raise those objections. So that is, informal process is easier. Personal representative's liability goes on longer. Formal process is a little bit more process, more hearings, more filings, probably a lawyer involved, but your liability is cut off much sooner. And so that's the difference between why the personal representative might want to use one process over the other. Like I said, this is a pretty important decision early on. You're asked early on, when you're filing your application, are you filing formally or informally? If you're in this situation trying to make this decision, we're happy to kind of talk you through it. And again, for estates that are in Colorado, we can help. And our phone number is 303-578-2745. We are the McKenzie Law Firm, and I appreciate you watching this video, and I hope this was helpful. Thank you.